Good evening, everyone, and welcome to all. Good evening, everyone, and a very warm welcome to all of you to our GST Masterclass today. We are truly grateful for the wonderful response we have received for the presence today. With the appellate tribunal now becoming operational, it has become very important for professionals, assessees, and tax teams to start handling their GST litigation. The purpose of today's session is to make GSTAT filing and procedures practical, simple, clear, easy to understand, and clear. We do not want this to be a theoretical discussion, but a practical one. The idea behind this session is that after today's session, GSTAT filing would be easier and simpler for you, and you would know how to prepare for the filing documents. But before we start our technical discussion, it is a privilege to call Mr. Pankaj Ghiya sir for his opening remarks. Pankaj Ghiya sir has more than 35 years of rich experience in tax litigation and advisory. He has handled several complex matters in GST, VAT, service tax, and income tax. And his practical experience before various appellate tribunals and High Court has been a constant source of guidance for all of us. So we are fortunate to have him with us today and to set the tone of this masterclass. So over to Pankaj Ghiya sir.
Hi, thank you, Sakshi, and good afternoon, good evening, everybody. It's a Friday, good afternoon, I would say, and we are all together for a learning session. Some people are always saying to me whenever we are having a discussion about the GST Appellate Tribunal that GST Appellate Tribunal has become very complicated. The filing is very complicated. It is very difficult to file. But my dear friends, as already informed to you in the last two sessions, it's really very simple. It's really not complicated. And if you go methodically, you go understanding the nuances of the filing, it's very simple. There is no question that you will be finding any complication or any difficulty in filing. And then you can file it in defect also. The portal will communicate you the defect and then you can rectify the defects also. So, friends, with this opening remarks, what I would be saying is that don't go with the presumption that it is very difficult. What we are doing is we are thrashing each and every comma, full stop of the sections of section 112 and the corresponding section and the rules. We are going through the GST Appellate Tribunal portal and finding it sometimes very difficult to understand what are the directions. But when we will be having a discussion about this filing today, and you will go through the PPTs and you will go through the deliberations of these expert speakers, you will find if you take all the documents in hand, you have an index of all the documents, you will find that there is no issue. But before that, let me introduce that today it is a special session. Special in the sense for the reason that this session we are doing it jointly with Udaipur Tax Consultants Association, Udaipur Tax Bar Association, and my friend Mr. Deepak Aaron, the president of Udaipur Tax Consultants Association, is joining today. And I would simply say, Deepak, please say hi if you are here in the meeting because I am seeing your name in the meeting. I would request my team to uh, unmute Deepak and allow him to say hi to all the participants.
Good afternoon, every participant, sir.
So, Deepak Aaron is the seasoned chartered accountant from Udaipur and he is the president of Udaipur Tax Consultants Association. And we are jointly doing this session with Udaipur Tax Consultants Association. Most of the professionals of Udaipur are also joining along with the professionals from all over the India. And friend, this is remarkable that we are crossing more than 325 participants today at the start of this juncture, and we will be crossing a huge number. And this shows the interest in the GST Appellate Tribunal procedures, filing, and the resolving of issues. I would say that normally when we file it, there are certain complications, certain issues which comes through the mind of a professional. How can we file it? It is simple. You go through a log in to the GST Appellate Tribunal portal, and there the indications and the guidance are there how to file it. But my team would be giving you a live filing session also, wherein an appeal would be live filed with each and every column being filled and shown how to fill it, and when there are difficulties, what are the difficulties and how to rectify those difficulties. They will be showing how to keep what documents along with you, because normally whenever you start filing an appeal, you should have certain documents. What are the certain documents? The show cause notice, the reply to the show cause notice, the appeal set, that is an optional, the order in appeal, that is the first appeal under section 107, then your grounds of appeal for the GST Appellate Tribunal, and all the relevant documents. There is a requirement of pre-deposit of 10%. That pre-deposit has to be paid. In certain cases, it is not required. But then there is a filing fee also, and then attestation and the workings. All these things would be there, would be live filing. But there are certain questions which we have to understand. Can we go directly from a show cause notice to the GST Appellate Tribunal? Can we directly file an appeal against a show cause notice? That is a consistent question which is coming to me time and again in each every master class, and even in the class, even in the physical seminar we had at Udaipur and many other places throughout India. I had been visiting time and again, and I had always said that filing an appeal before the GST Appellate Tribunal is only against the order passed by the Appellate Authority under Section 107 and 108 only. You cannot file an appeal directly from an SCN to the Appellate Tribunal, because that jurisdiction, SCN, can be challenged only by way of a writ petition by before the High Court in, under Article 226 of the Constitution of India by filing a writ petition, that too on a legal ground or other grounds. There are certain queries. Okay, sir, if we had filed some appeal before the first appellate authority and that appeal has been time barred, how can it become time barred? The time limit for filing of first appeal was 3 months plus 1 month of delay condonation, but the appeal has been filed beyond a period of 4 months, and the appeal has been rejected on the ground of limitation. Now, can the tribunal condone that delay? So, friends, again, you have to understand that tribunal is a creature of statute. Tribunal has been formed under the CGST Act, under the SGST Act. It cannot go beyond what is written in the statute. And therefore, if the appeal is time barred, if the appeal is, not in the limitation period, then you have only option to file a writ petition before the where High Court under Article 226 of the Constitution, and that is the only option where you can go through, because the rejection of the appeal before the first appellate authority on the ground of limitation, the remedy lies going to the High Court and not going to the appellate tribunal. The other questions which comes into forth is whether, if there is a challenge to a virus of a section, what is a virus? You want to say that 16(2)(c) is ultra virus, is not correct, is not legal, it is disputed. The refund section 54, it is not correct. The limitation in section 54 of filing of 2 years, it is not correct. Then what to do? Then you have to challenge the virus of a section before the High Court only and not before the appellate tribunal. So, friend, you have to understand that appellate tribunal is a statutory remedy. It is not an extraordinary remedy. It is not a place where you can challenge the virus. So, for challenging the virus, there are now two segregation. There are two different ways. One way is when you go through the statutory remedy, that is from the SCN to the order in original and order in original to order in appeal, and then to the second appeal, that is the appeal before the GST Appellate Tribunal. You have to file the appeal before the GST Appellate Tribunal on the portal. But if you want to challenge any circular, challenge any notification, challenge the limitation period, challenge any section, then you have to go to the High Court only and not go to the Appellate Tribunal. So don't do that mistake. Don't try to, because once you will file an appeal, and if the tribunal says that we are not able to decide upon it, then the time would lapse, and even the High Court may interfere or may not interfere. There are some other things. Some people say, sir, if we do not have remedy, if the appeal before the first appellate authority has become time barred, what is the remedy? File a writ. In many of the writ petitions we had filed before the Rajasthan High Court, they had given time to further file the appeal within 15 days or within 4 weeks before the appellate authority, and they had condoned the delay. That order would also be shared to you in the group, and add yourself to the group of Ghiya Legal, and you will find the updates regularly. There are many more issues. The issue is at this juncture that you must file the appeal before 30th June 2026. Now the question is, what appeals before 30th June 2026 has to be filed? That you have to understand the order in original which has been passed, or order in appeal which has been passed up to March 31st, 2026. The appeal has to be filed before the GST Appellate Tribunal up to 30th June 2026. From 1st April, the normal limitation, that is 3 months plus 3 months of condonation, as provided in section 112, would start. But there are many other issues which would be cropping up in your mind. Write down all your queries in the chat box. I will be coming again after the end of the presentation by the two great speakers. You will be hearing the live presentation and the PPTs, and you will find all your queries answered by these two speakers. But then, if you have any queries, write it in the chat box. We will be answering each and every query, and at the end of the session, we will be taking a live question answer session also, where you can put any of the queries, and then we will be answering all those queries you had been asking or you are putting here. Start putting the queries right now, and I would now ask my team. The first speaker would be Sakshi Ghiya. She is a chartered accountant. She has been in practice. She is filing the appeal in and out regularly. She is also arguing the appeals before the GST authorities, going to the GST department, and she has a good experience of explaining how to file the GST appeals before the GST appellate authorities. So over to Sakshi Ghiya now.
Thank you so much, sir. So we just start. Yes. So, as for the last 9 years, one of the biggest gaps in the GST litigation was the absence of a functional second appellate forum. And now, with the tribunal now finally becoming operational, a major pending litigation line is going to move forward. So, before I start the entire presentation, I would be covering up all the procedural aspects of the GSTAT tribunal, which is basically your limitation, pre-deposits, statutory filing fee, rules for authorized representatives, and other common issues. And then followed by the live filing presentation by Mr. C. Ribhav Ghiya. So, as we all know that in GST, the starting of the litigation is the issue of show cause notice or ASMT 10. It should be under section 73, 74, 108, and so on. Sorry, section 73 or 74 by proper officer. In the SCN, we file a reply, and if the authority does not accept the reply, then there is a OIO which is passed by the adjudicating authority under section 73 or 74. After that, then if you are aggrieved by the order of the OIO, like by of the adjudicating authority, you can file your first appeal under section 107, to the first appellate authority. Also, there can be a revision authority under section 108, which can pass orders against the departmental orders passed. If any department has passed an order which is aggrieved by the departmental authority, higher authority, then they can pass an order. After the section 107 or 108, the next line of litigation comes the GSTAT Tribunal, which is what we're talking about, section 112. If you agree by the order of GSTAT Tribunal, then we go to the High Court. And if you agree by the order of the High Court, we move to the Supreme Court. So if you see in this case, the GSTAT is a very important forum because it is actually a final fact-finding authority in majority cases. Because when you can approach the High Court and Supreme Court for majorly substantial questions in law, but in case of factual finding authority, it is only which GSTAT tribunal would have major powers to decide on. Also, we need to understand that GSTAT filing is not actually very difficult. If we have a proper checklist and we do our preparation in a disciplined manner, we can actually make this procedure very simple. Moving forward, GSTAT under section 109 of the CGST Act has divided the tribunal into two benches. First being the principal bench, which would be located at the New Delhi, and second is the state benches, including the circuit benches, which will be 31 state benches have been allotted as now across 45 cities. So this is the basically the division of our benches. The composition of the principal bench would be of president, a judicial member, a technical member of a center, and a technical member of state. Whereas, whereas in the state bench, the the composition would be of two judicial members, one technical member of center and one technical member of the state. So we have to see that it's actually they have created a federal structure where they've included both the center and the state both have a role in it. Also, in the state bench, the senior most judicial member would be considered and notified as a vice president, and it would has similar powers as prescribed to the president. If you are aggrieved by the order of a principal bench, we will come in later what which appeals will be filed under the principal bench. But if you are aggrieved by the order of principal bench, you do not have to go to the High Court. You can directly go to the Supreme Court of India. I mean, you have to go to the Supreme Court of India if you agree by the order of principal bench. However, in case of the state bench, if you agree by the order of the state bench, then you have to first appear before the jurisdictional high court, and then if you agree by that order, you can take it to the Supreme Court. Apart from that, now we move forward to the exclusive jurisdiction of the principal bench. So what bench, I mean, when we have an order with us, we need to decide we have to file an appeal before the principal bench or the state bench. And how do we decide that? So that is decided that in case of these six matters as of notified as of today, you have to file your appeal for the principal bench, which is located at New Delhi. Apart from any other of these matters, which is listed down here, any other matters have to be taken up to the state bench or of your respective jurisdiction. So, which are these matters? Which exclusive jurisdiction of the principal bench? First is the place of supply matters, which is basically if your transaction is interstate or intrastate, that is, if CGST or SGST is applicable or IGST is applicable. So even if any one of the issue is of the place of supply matter, then the matter has to be taken to the principal bench and it would not go to the state bench. Secondly, in case of any OIDR services under Section 14 or any non-resident taxable person under Section 14A of the IGST Act, so any issues involving here would also be taken up by the principal bench. Any ISD credit distribution under Section 20, appeals have to be taken up by the principal bench. Any anti-profiteering matters under Section 171(2) of the CGST Act would also be taken up by the principal bench. Any identical questions of law pending between two or more state benches, and also the appeals made under Section 101B, that is the National Appellate Authority of Advanced Ruling Matters, this is AAAR, with effect from 1/4/2026, principal bench has been given that responsibility to take care of those matters as well. So you have to decide before you get your order, before your client comes to you and he asks what to do, then which bench would you actually file your appeal before? That is very important. One minute. After that, what is important is the division and the single member bench. So under each bench, then there will be two types of benches, which is either the principal bench or the state bench. There will be two types of benches, which can be your single member bench, which is either held by a judicial member or a technical member, or a division bench or a double bench, as you can call it, which is a judicial member and one technical member would be handling it. So, what are the matters will be taken up by a single member bench? Is basically if any tax, ITC, fine, fee, or penalty does not exceed rupees 50 lakhs, if it's less than 50 lakh rupees, and there is no question of law involved. This is a very, it's a, like a and condition where both the conditions have to be satisfied. So if your amount is less than 15 lakh for your dispute and there is no question of law involved, then the matter can be taken up by the single member bench. And in any other cases, the member has to the appeal the matter has to be taken up by the double member bench. But if the same issue for same appellant was earlier decided by a two-member bench, uh, and then the similar matter, even if the limit is less than 50 lakhs and it's not a question of law, it should be handled by a single member bench. But if it's already similar matter has been taken up by the member bench for the same client, then that matter has to be taken up by the double member bench. So this is actually mentioned in section 109 of this 8 of the CGST Act, and the rule 110A of the CGST rules clearly mention the division and the responsibility and the matters which will be taken up by both the division and the single member bench. Recently, an office order number 3 was passed, dated 14th May 2026, where basically they divided all the matters into three categories. And, the category one being the core tax disputes, which is classification, notification, time and value of supply, place of supply, etc. Category two being, like a registration or cancellation or revocation or recovery, refund issues. And category three being other issues like seizure, confiscation, rectification, or any provisional attachment issues. In that case, the category three would be there. So this is what they have written is basically they have categorized these are the issues, and this will be taken up by which either a judicial member or a technical member under each state. So state wise, they have mentioned that in the office order. You can refer to the office order number 3, and you can find it on the GSTAT portal as well. And state wise, you will know which judges would be taking up which matters. Also, any matter would be first listed before the division bench, and then the division bench will decide that they want to transfer it to the single member bench or not. So all the matters will be first listed with the division member bench. Also, the category 3 matters will be heard with the bench dealing with the main issue. For example, in case there's a section 74 demand and along with that a provisional attachment was done. So if the section 74 demand is being appealed against, so and it's taken up by the category 1 bench, then in that case, even the provisional attachment, even though it's a category 3 issue, would be taken up by the same bench. Now, with the most important being the section 1122 of the CGST Act, which actually tells us which appeals can be filed before the GST Appellate Tribunal. So, any person aggrieved by the order passed under section 107 or order passed under section 108 may file an appeal before the GSTAT tribunal. So 107 is orders of the first appellate authority and 108 is the orders of the revisional authority. So for any of these orders, you agree by them that you can file before the tribunal. That means that no show cause notice, no order in originals can be directly filed, up for appeal against the GSTAT. You have to, follow the litigation procedure and the litigation bodies which have been created by the Act. Also, there has been a pecuniary appellate jurisdiction, that is that the tribunal may refuse to file, to take the appeal if the demand does not exceed 50,000 rupees. But this is a may; it's not compulsory. But this becomes very important because sometimes the amount would be less, but it would be a recurring issue, an important recurring issue. maybe of classification or exemption. And in that case, then you have to decide that you have to file an appeal before the tribunal. And if the tribunal still does not accept it, then you need to file another remedy, that is through writ, to be taken up, because this is a monetary limit, but it's not a compulsory limit. The tribunal still has the right. So you have to you decide according to the importance of your matter. Also, the right to appeal is a statutory and substantive right, and it's been a right provided under the CGST Act. However, Section 121 of the CGST Act clearly talks about 4 cases where you cannot file an appeal. These are basically your procedural or administrative, orders, and not any tax demand orders. So, in case of any transfer of proceedings or any orders regarding seizure or retention of books, or any prosecution order, or any order passed under Section 80 for installment of payment of tax. So, no orders can be passed before the appellate tribunal or the first appellate tribunal against this, to them. However, that does not mean that you cannot have an alternate source of remedy. You can still, if you want to file and you feel that this is you agree by it, or there is any violation of national justice or any such issue like that, then you can still file an writ petition against these orders before the jurisdictional high court. Now, starting with the most important, the limitation of filing of appeal, which is covered in Section 112(1) of the CGST Act, which also has been somewhere covered by Pankaj sir. So, any orders, before we actually start, I would like to read Section 112(1), which says an appeal has to be filed within 3 months from the date on which the order sought to be appealed against is communicated to the person filing the appeal. So, what is important here to understand is, first, you're getting 3 months from the date of communication of the order and not from the date of the order. And the person, who's aggrieved by this order can file the appeal against this order. So, for orders communicated before 1st April 2026, that is all your pending orders, maybe since 2017, any first appellate orders which have been pending, orders have come and you did not have a tribunal operation now. For all of those orders before 1st April 2026, you have to file an appeal up to 30th June 2026. However, all orders after 1st April 2026, the orders, I mean the order in appeal of the first appellate authority or the divisional authority. Only those orders that from that date communicated on or after 1st April, then a normal 3-month limitation period applies. So this is a critical deadline for pending matters. And what is important here is to note that it is from the date of communication of the order and not from the date of the order which is written on your order. And the date of communication of the order is covered by Section 169 of the CGST Act, and which clearly says the different modes which allows for the communication of order, which is through your portal, through email ID, registered email ID, to registered post, and some other modes. So you have to see when you have received the date of communication order and accordingly file your this. Now, what becomes important is the manner of computation of limitation. So, the Rule 3 of the GSTAT Procedure Rules mentions how these 3 months have to be calculated. So, firstly, you need to note that this 3 months means British calendar months, which is your January, February, March, and does not mean 90 days, which is usually our cases in other matters. Secondly, you need to exclude the first date, of the day the order was communicated to you. So, you can remove that, and from the next day, you start your 3 months calculation. Thirdly, if there is, if the last date from your calculation comes out to be a Sunday or a GST close day or a holiday, then that day is again excluded, and the next working day is considered to be the last day of filing your GST appeal. So, just to take a simple example, if your order was communicated on 1st August 2026, so you exclude 1st August, you start your limitation from 2nd August 2026, and from there, August, September, October, November. So, your limitation period ends at 2nd November 2026, but assuming 2nd November was a Sunday, then in that case, the next working day, which is if it's a Monday, would be considered as the last day of filing of appeal. So this is very important because you need to file your appeal on times. And we have always observed that in tribunal matters, usually the first objection which a registry has is that appeal, of a limitation. The appeal is not filed on time. So please ensure your appeal is filed on time, and also don't wait for the last date for filing your appeals. At least file 7 to 10 days in advance, because since the tribunal portal is very new, there would be a lot of um, like a lot of issues which you could face while filing your appeal. Then starting, then what is the condonation of delay? Section 1126 provides a condonation of delay, that is, apart from the 3 months of filing of appeal, further 3 months are allowed if there is a sufficient cause to be shown, and hence the total time allowed to file your appeal is 6 months from the date of communication of your order. But beyond 6 months, if you're filing your appeal and it's rejected by the tribunals, then you can of course file a petition before the jurisdictional high court. But as per the GST Act, CGST Act, the period limitation and the time period and condonation given to you is 3 months plus 3 months. In case of first appeals, it was 3 months plus 1 month, but right now in before the tribunal, it's 3 months plus 3 months given. However, sufficient cost has to be shown. If sufficient cause is not shown, then they can reject a condonation. So your condonation should be very, should show how much delays happened, what is the reason of delay, what is the documentary evidence you have. In case it is a medical emergency, you can have a medical certificate. In case you approach the wrong, remedy, you can have that you appealed against the high court mistakenly against the wrong advice, or whatever your reason would be, or you have received your email or through a registered post much later. So you can have all your documentary evidence has to be saved for this condonation of delay. You cannot just write a condonation with that there was unavoidable circumstances that won't be accepted by the tribunal. So a good condonation of delay has to be prepared and drafted while filing your tribunal appeal if you have crossed the 3 months. Next, moving to the pre-deposit, which is section 1128 of the CGST Act, which clearly says the pre-deposit to be paid. So the pre-deposit in the first appeal, as we know, was the 10% of tax, and later on it was 10% of penalty in case of only penalty demands. Similarly, in the GSTAT, if you have to file your appeal, you need to pay 100% of the admitted tax, interest, fine, fee, or penalty. And in case of the disputed amount, if it involves tax amount, then it has to be 10% of the tax amount, with maximum 40 crores as your cap. So CGST Act 20 crores, SGST Act 20 crores, or IGST Act 40 crores. That's the monetary cap given. However, in case of only penalty demand orders, then 10% of the penalty amount has to be paid as a pre-deposit. Your appeal won't be accepted unless you have paid your pre-deposit. Also, very important to notice that once you have paid your pre-deposit, your balance demand is stayed automatically. So you don't have to file a separate stay application to, keep a stay on your balance demand. Once the pre-deposit is paid, your demand is stayed automatically. So example for pre-deposit is, just I've given an example, that a total tax demand, if it's of 50 lakhs, and admitted is 10 lakhs, and the disputed tax is 40 lakhs. In that case, the first appeal, you need to pay 100% of the admitted tax, that is 10 lakhs, plus 10% of the disputed tax, that is your 4 lakhs rupees. However, in the first appeal, even the first appeal does not accept your appeal, then when you appeal for the tribunal, you need to pay an additional 10% of the tax amount, which is your 10% of 40 lakhs, 4 lakh rupees. And hence the total pre-deposit paid till now is 100% of admitted tax 10 lakhs and 8 lakhs for your disputed amount. So that's how you would be calculating your pre-deposit. Also, I mean, we recommend that always create a pre-deposit internal working sheet so that you know how much you've paid, because there's sometimes demand is already paid, and you need to calculate that from there you've already paid your demand through the RC03, and then from the RC03A you can adjust that demand. So we always recommend that always create an internal working sheet for your pre-deposit amount to understand how much is actually liable to be paid. Also, the payment of pre-deposit has to be done to the GST portal. An electronic it can be paid through the electronic credit ledger only for your output tax amount and not for your RCM, interest, penalty, fine, or fees. However, if for RCM, interest, penalty, fine, or fees, you have to make the payment of your pre-deposit through the cash ledger. You cannot make a payment through the credit ledger. So moving forward, apart from the GSTAT, pre-deposit, there is an additional payment which we have to pay, which is the statutory filing fees. What is important to note here is that the GSTAT pre-deposit amount can be refunded if your appeal is accepted by the tribunal, but your statutory filing fee is actually a court fee which will not be refunded even if your appeal is accepted. So statutory filing fee has been mentioned in Rule 110 of the CGST rules, and which mentions that a minimum fee is of rupees 5,000 and a maximum fee of rupees 25,000 and rupees 1,000 for every 1 lakh of tax amount in case of tax amount involved. And in case of only penalty orders, only fine orders, then that is you have to again calculate rupees 1,000 of every 1 lakh. So in case if you have a tax, interest, and penalty, then only the tax amount would be taken, and every 1,000 of tax amount would have to be calculated with a maximum cap of rupees 25,000. And in case if your order does not involve any tax, interest, fine, fee, or penalty, which is basically your registration, cancellation order, or your refund order, in that case, there is a flat fee of rupees 5,000 which has to be paid. So I hope this is very clear that this is a separate fee to be paid, and you need to make this aware to your clients that there are two different statutory payments made under the GSTAT tribunal. So just to create a example, so it's much clearer to you. In case of you have a refund rejection order of rupees 50 lakh rupees, even that you have to pay a flat fee of 5,000 because there's no tax amount or penalty amount involved. In case of registration cancellation order, again you have to pay a flat fee of rupees 5,000. In case of only penalty demand of rupees 20 lakhs, then you would have to consider 1,000 for every 1 lakh and accordingly pay 20,000 as a statutory filing fee. In case there's a tax of 8 lakhs, interest of 2 lakhs, and penalty of 8 lakhs, in that scenario, you have to pay 1,000 of every 1 lakh for the 8 lakh amount, and that would come to rupees 8,000 rupees. So 8,000 has to be your statutory filing fee. So I hope it's clear. Secondly, you cannot pay these fees through the GST portal, which our normal GST login portals are. This has to be paid through on the GSTAT portal, which is the tribunal portal when you're filing your appeal, and it is paid through a Bharat Coast platform. So there's a Bharat Coast platform. Through this, you have to pay your fees. Also, if you do not want to make an online payment through the portal directly, you can visit the Bharat Kosh portal there and create, an receipt confirmation, and then you can submit your acknowledgement while filing your appeal on the portal. So you can also do that. So if in case you're not able to pay it online, then you can visit the portal and make the payment later and submit a copy of your acknowledgement. Moving forward, interlocutory applications, these are filed usually during the pendency of appeal. And they are basically applications like application for stay. So stay application, if you've paid your pay deposit, you don't need a stay application. But for other cases, like if you have a block credit ledger, you might need an application for stay, and some other cases. Then earlier hearing cases, in case you need an early hearing because your bank account is attached or something, then you need to file a early hearing application for urgent matters. In case of continuation of delay, in case of any directions you want to be issued, in case of rectification of order, and in case of any extension or exemption of time you need. In that case, interlocutory applications have to be filed before the tribunal. They have to be filed in a GSTAT Form 01 with a supporting affidavit. The fee to file each interlocutory application is rupees 5,000 rupees. So even if you're filing like application for stay 5,000 right now, then later on you file early hearing, then again 5,000. So you have to file that. Only for rectification application, there will be no fee applicable. Only for the rectification application. And this is covered in Rule 29 of the GSTAT Procedure Rules. This is a format of the GSTAT form, and it's similar to, you have to make a statement of facts, grounds of appeal, and prayer, but it has to be very short and specific and not like a very detailed appeal. Moving forward, then there is a schedule of fees. This is just a general fee schedule, which is For inspection of records, you have to pay a fee of 5,000. For interlocutory, it's 5,000. For any other application not specifically mentioned, again, you have to pay a fee of 5,000. And for obtaining certified true copy of final order, passed to parties other than the concerned parties, that is third parties, if you need a certified true copy, then rupees 5 per page would be the fees. Department authorities are not required to pay any fees on appeal or application. Now, moving forward to what is the last stage for the thing I would have to take for today is basically the authorized representatives who can represent before the tribunal and what are the rules for them. So the taxpayer himself can represent, any relative or regular employee can represent, an advocate can represent, a practicing CA, CS or CMA can represent, a retired officer of any commercial tax department can represent, and any authorized GST practitioner can also represent. This is clearly mentioned in section 116 of the CGST Act. And when you represent, you have to file your representation, that is your memorandum of appearance or letter of authority or wakalatnama in GSTAT form 04. This has to be submitted to the authority along with your wakalatnama or authorized representative. The rules for the GSTAT authorized representatives, which will be covered, is basically you can appear before the GSTAT only filing after your wakalatnama in form 04. Secondly, a new representative can appear only with the written consent of the existing representative. So if there's an existing representative on your case and you are a new person, the company is appointed, then you have to take a permission. If you're not able to get the permission, then you have to take a permission of the tribunal in that case. If the representative who have previously advised or represented a party cannot switch sides to represent the opponent. If you presented one side of the party, you cannot again represent the opponent party as well in the same or related case. If a representative is appointed, the GSTAT may restrict the party from arguing personally because they already have a AR on its place. The GSTT will also maintain a panel of ARs, valuers, or experts to assist the bench whenever required. An AR must wear the prescribed professional dress before the GSTAT, which is mentioned in the GSTAT Procedure Rules 122. So, in case of a authorized representative having professional dress already as per their prescribed dress code, like lawyers would have a dress code, then they would must appear in that. However, if no professional dress code is prescribed, then in case of a male authorized representative, you have to wear a close colored black coat or an open collared black coat with white shirt and black tie. In case of female, black coat over a white sari or any other white dress would be okay. There's a summer relaxation given from 15th April to 31st August. Black code may be dispensed with. And also that rule 112 does not strictly apply to the relative or the employee or the party himself, but they still should, maintain a decent attire. Also, this dress code has to be, has to be also taken care when you're doing virtual hearings. This is not only when you're doing physical hearings, even when you're doing virtual hearings, the dress code has to be maintained. And the lastly, just the general procedure rules that the sitting hours of the GSTAT is 10:30 a.m. to 1:30 p.m. and 2:30 p.m. to 4:30 p.m. Where the bench will sit. Office working hours are 9:30 a.m. to 6 p.m. Appeal has to be filed online. As of now, there has been no manual appeal required filing. Causes will be published on the portal or notice board. Hearing can be both physical or virtual as permitted, and you can take adjournment allowed by the bench before, on suitable terms and beforehand. So now we would be moving forward to the most important part of this webinar, which is your live filing, and that would be taken by CA Ribhav Ghiya, and he has been experienced and been regularly filing now the GSTAT tribunal appeals as of now. So he'll be taking up that, and then we will be moving to the live Q&A with Pankaj Ghiya, sir. Over to Ribhav.
Hello, good evening, everyone. So now we will be starting with the online filing of the appellate tribunal. So just to start with, I will give you a brief how to file and where to file the appeal. So the appeal filing website is efiling.gstat.gov.in. Here we have to file the appeal online, and we have what are the prerequisites? The prerequisites are that we have to register as for the appellant or the taxpayer who for whom we are filing the appeal. Authorized representative registration shall also be required, and the GST login details that is on the portal of the gst.gov.in. That login details shall also be required. The pre-deposit for filing the GSTAT appeal, it has to be filed on the GST portal, that is the gst.gov.in. The challan should be deposited or the e-credit ledger adjustment shall be made. It can be made via two options: the payment through the ledger option in the service portion, or through form DRC03A when we have filed the DRC03 in advance. So now, before starting the filing of the appeal, I will give you the preparation points for appeal. We have to make a complete case file and a complete folder evidencing the show cause notice, the reply against the show cause notice, the order in original, the first appeal, and the appellate order, and the GST appeal that we are filing, the statement of facts, the grounds of appeal, and the prayer. We have to make it in a complete folder and then file it accordingly. We have to make a proper demand breakup, that is the tax interest penalty part, because we have to file each and every detail on the GSTAT portal that I will be showing you further. Then we have to prepare the issue wise summary, that let's say there is an order which has a ITC mismatch, short payment of tax demand, and some valuation demand. So we have to prepare each issue point wise. We have to make grounds of appeal of each issue point wise, whether it is ITC mismatch, and on the GSTAT portal also we have to submit that in each category. Then we have to prepare a chronology of the dates. That is the ASMT 10 issued, the show cause notice issued, the reply to show cause notice filed, the hearings done, the APL 01, that is the appeal which has been filed, and the appeal order on which date the appeal order has been filed. So it is always advisable, since GSTAT portal has a limited session, we can always use the draft online filing facility provided by the GSTAT portal. In that we can fill all the tabs, each and everything, and then submit copy pasted to the GSTAT portal. It saves time, because sometimes the sessions log out from the GSTAT portal. Now, during filing of appeal, the things which are required during drafting, we have to take care of following things: the appeal header. In when we are submitting the grounds of appeal or the statement of facts or the prayer, there should be a header stating that in the goods and service tax appellate tribunal, and the order being challenged, the details of the order being challenged, the appellant detail, the respondent detail shall be clearly mentioned uh, in the start. All the paragraphs shall be consecutively numbered and covering each statement of facts, legal issue, and ground which is being raised. Now, and each page shall be numbered, and each party shall be numbered. Like if you are three authorized representatives, then all the three authorized representatives shall be mentioned in the GST APL 05, and they shall be numbered 1, 2, 3. Then there is the filing matrix. The filing matrix is very important to understand. So let's say there's one single order in original issued. Then we have to file only one single order in appeal. We have to file only one appeal before the first appellate authority, and against that order, we have to file only one appeal before the appellate tribunal. Let's say there were multiple order in original issued, against which we filed appeal against all the order in originals, and the authority, the first appellate authority, has passed one single OIA covering all the appeals that has been filed, irrespective of the fact that one order in appeal has been filed. One order in appeal has been given by the first appellate authority. We have to file separate appeals before the GST Appellate Tribunal against the multiple OIOs. So, friends, for each APL 01 generated, we have to file one APL 05. before the GSTAT. Similarly, if there is one single OIO, then we have to file one single appeal. If there is one single OIO covering multiple parties, then for each party, we have to file GST appeal before the appellate tribunal. Moving on. These are the content formatting requirements given by under Rule 20 of the GST Appellate Tribunal Procedure Rules. So the grounds of appeal should be brief under separate heads and consecutively numbered. The formatting shall be on the A4. The format should be set on the A4 paper and should be double spaced. The all the pages shall be indexed, tagged, and submitted on the GSTAT portal. All the pages shall be signed. Not all the pages, at the bottom of each application. The page should be signed and verified by the party or the authorized representative. Now we will start the online filing. So let me log out. Yes. So this is the GSTAT portal. Now we click on login and submit the details of the taxpayer against for which we are filing the appeal. So I've already saved the details and I would be filling that. So here's the captcha. So we have logged into the appellate tribunal website. Now we will start with the continue. So here there is a disclaimer that the appeal is being filed under section 112 and all the conditions have been prescribed are being fulfilled. So we will click on agree and go on continue. So here you can see I've already prepared a case file for everyone to see. So we'll starting with this. So here is the basic data. I will go to the first page where we have to fill the order details and start from there. So friends, here is the select ARN filing option. That is the ARN CRN available. We have to first examine whether the order against which the appeal is being filed, the APL 01 was filed online or offline, whether the appellate authority has passed the order offline or online. If the order was filed online and the appeal was filed online against that and the APL 04 has been generated on the portal, then we have to select the option of ARN CRN available. Similarly, if the order and the appeal against the order in original was filed offline, then there would be also an option coming ARN CRN not available, and we have to select that option when the order has been passed offline. So since in my case the order is available online, I would select ARN CRN available and then fill the order number. So when I fill the order number, the automatically all the details will be fetched from the GSTAT portal. That is the order being appealed against. That is the APL 01, APL 04, the authority order number, the appellant name, the order type, which is the demand order. If the order was a revisional order, then the or a refund order or registration issue, then the here the narration would change to demand order or registration order or to a refund order. Then the authority who has passed the APL 04, that is the order in appeal, the date of passing of the order in appeal, and the communication date. So, friends, it is very important over here. So, if we are filing a manual appeal or again, appeal against a manual order, it is very important that the date of order and the communication date shall be checked properly. So, if the order was passed offline and the assessee or the authorized representative who has received the order has received the order on the after 10 days from the date of passing of order, then the communication date will be taken after the 10 days. So in my case, since the order was already uploaded on the GST portal, so the date of communication and the date of passing of the order are same. Then the order ID of the original adjudication order, that is the order in original, and the date of the original adjudication order. The period of dispute, in my case, the period of dispute is from April 2018 to March 2019. Then the value of seized goods, if there is any, and the impugned order. So you can always check the impugned order. So here we can, on the GSTAT portal, we can check by clicking on the view order option, and you can see the APL04 has been correctly fetched on the GSTAT portal. So moving on, once we fill all the details, if we are filling manually or if we have selected the option of online, then all the details will be auto filled, and you just have to click on confirm button after that. So as you can see, so now first let me explain what is the issue against why the order has been passed. So in my case, the order was passed by the original adjudication authority on 29th August 2023. The issue relating to this case was very simple. We filed GSTR 3B and showed import. On the import option, when we filed GSTR 3B and point 3.1b, we filed the supply was shown with the payment of tax, whereas in GSTR 1 we had shown supply was shown without payment of tax. So we accidentally paid the tax amount in 3.1b of the GSTR 3b. So after reconciling, the assessee uh, claimed the tax paid in the ITC portion, and due to which there was a demand raised. As you can see, the demand was raised regarding the excess ITC claimed. So as you can see, the demand was raised in the IGST head of 11,60,000 along with the interest and penalty. So this is the issue. Now we will go over here now on the GSTAT portal. So as you can see, the GSTAT portal starts with the after filling the case order details. It will ask against which act you are applying the GST appeal before the tribunal. So we'll select the IGST Act in my case. But if there was a demand in CGST Act and SGST Act, we would select the CGST and SGST Act also. So if there is a demand in IGST, if there are multiple issues in the order, then for each act, the demand raised, we have to select each act. So if there was, let's say, CGST Act demand also, and SGST Act demand also, and IGST Act demand also, so I would select CGST and SGST also. Along with that, I will select IGST Act also. So in my case, since the order has been passed in IGST Act and the demand has been raised in IGST head, so I will select only IGST head. Then the case type, whether the against which we are filing the appeal. So the case type is appeal, since we are filing the appeal under section 112 of the CGST Act. And now it is an important question. Does the appeal application involves any issue over which the principal bench has jurisdiction in terms of the provisions of the act or rules? So, friends, here the issue comes whether we have to classify the issue, whether the issue is relating to place of supply or not. If the issue is not relating to the place of supply or any other reasons which has been mentioned before, then the principal bench does not has the jurisdiction, and we will select no. Then the jurisdiction of the appellate or revision authority. Here we have to go into the order of the appellate authority and check who has passed the order. So in my case, the order was passed by the state tax authority. So I have to select state. Similarly, if the order was passed by the central tax authority, then I have to select the central jurisdiction and the state zone of the appellate authority. So in my case, the order has been passed in Rajasthan state. So I would be selecting Rajasthan. So again, has the original order of adjudication has been passed by common adjudicating authority. So these are the cases where the DGGI has passed the order. So the in some of the cases, the DGGI was authorized to was being made a common adjudicating authority of all the states. So in my case, since the order has been passed by the state tax authority, there is no question of common adjudicating authority, and so we'll select no. Then the who has passed the order we have to mention. So friends, it is very important that we have to select the proper appellate or revision authority jurisdiction. So in my case, as you can see from the bottom of the order, the order was passed by the appellate authority 1, room number 116, Karbhavan, Jaipur, and the jurisdiction is Jaipur I, Rajasthan. So we will select Appellate Authority, State Tax, Jaipur I, Jaipur. Then we click on Save and Next. So now comes the main gist of the GST Appellate Tribunal filing. So here we go to the case details. As you can see, I've already pre-filled each and everything. So I would be showing you this. So basically, the case detail is that we have to mention the grounds of appeal in brief, the brief of the case or issue, brief issue of the case under dispute, and the prayer, the prayer that we are taking before the appellate tribunal, whether to quash the order to set aside the order or to remand back the order, or to provide us with the refund of the pre-deposit once the order has been set aside. So all the grounds are very important and has to be raised in the prayer section, but there is a limitation at the time of filing on the GSTAT portal. So they have given two options. If your order, you have to give your grounds of appeal in brief up to 2000 character limits, and if you have elaborate grounds of appeal, statement of facts, and the prayer, then you can upload it as a document at the time of filing. Upload document. So here, in the grounds of appeal in brief, I have prepared a short summary. What was the grounds of appeal? Why there was no proper opportunity granted to me. The demand was raised without any reconciliation or reply being considered, and my contention before the appellate authority and before the appellate tribunal. Similarly, the facts of the case, that the demand was raised on the show cause notice, the show cause notice against which reply was filed, and then from the reply, the order in original was passed. Then I filed the appeal. During the appeal was presented before the first appellate authority, and during the personal hearing, he did not consider my submissions and passed the order in appeal. Similarly, the prayer, what is my prayer before the appellate tribunal, and it is very important, friends. It is very important that we give proper present a proper prayer. We have to take all the points, whether the order has to be set aside or liable to be quashed, and the pre-deposit refund shall be made once it is set aside. Further, the tax ITC reversal shall be given to us. All the things and any additional hearing shall be granted in case the order is being passed against our favor. All the things have to be all the things have to be mentioned in the prayer section. Now the category of the case, it is again very important point. So the category of case, so I will first show you what are the categories as mentioned by the Sakshi ma'am. So here, I will show you what are the categories of the case. Just a minute. So there are three categories, and we have to mention each category or select each category very importantly. Because if we select the wrong category, it can get passed on to a different to a different level. So if the category is relating to the disputes, relating to the classification, notification, applicability, time value of supply, or the short payment of tax, or ITC excess claim ITC, then we have to select the category one, and we have to select it very importantly. So in my case, since the demand was raised on me for the excess ITC availment under section 73, so I selected this section. Let's say in my order, if there was a demand raised on excess ITC availment and short payment of tax, then I have to show each ground, each issue which has been raised upon me as different. So I have to select one more. I have to add one more category and select short payment of tax. So as you can see, tax wrongfully collected or tax excess ITC availed, or so we have to select each and every determination of tax not paid or short paid, each issue properly, and mention each issue, the GST section under which the demand has been raised, the rule along with the section, and the amount involved. So if you can see, in my case, the demand was raised for 11,60,000. So this was the excess ITC availed. So the department has raised upon me the demand and the amount has been written only of the demand raised in the tax portion. Similarly, if there was a short payment of tax demand raised upon me, so I will write the tax payment demand. Since in my case we are only moving with excess ITC availed, so I will be deleting this. Now comes the case summary. Here again, it is very important that we fill each and every tab very properly, because this would be submitted before the appellate tribunal and the members. So, what is the issue related to? Since in my case, the issue is related to denial of ITC. Due to some error on the portal regarding on this, there is no option coming of denial of ITC. Otherwise, I would have selected the denial of ITC option. But we have to select the whether it is denial of ITC option, or short or non-payment of tax option, or the levy of penalty, or the levy of interest, or if there is any classification dispute. So in my case, there is denial of ITC. So I've selected short or non-payment of tax. Now we have to fill what was done by the order of adjudicating authority. So here we have to fill the details what was done by the adjudication authority. So the adjudication authority passed the order in original dated 29th August 2023 and confirmed the demand. And along the demand was raised on the allegation. So we will write a short note why the demand was raised, and what amount of demand was raised by the order of the adjudication authority. Then we will write what was determined by the appellate or revision authority. So in my case, so the appellate authority confirmed the demand which was raised in the order in original. So he confirmed the demand and no relief was granted to me. But if there is a case where the appellate authority has passed a partial relief against the order in original, so we have to write those details also. So we have to write if there was any partial relief provided by the appellate authority, so we have to write the demand. The order in original raised a demand of, let's say, 10 lakh rupees, and the partial relief was provided to us of 5 lakh rupees. So the after that, we have to write the demand now pending before the appellate authority is rupees 5 lakh rupees. Now, what is the stand of ours before the tribunal? So this is very important. So since in my case, the appellant disputes that the entire IGST tax demand was raised of 11 lakh 60,000. I am saying that the case is not of excess or ITC availed. It is a case of revenue neutral. It was a bona fide mistake on the part of the assessee, due to which the demand was raised. And since there was no loss to the revenue and the entire case is revenue neutral, then the IGST demand shall not be is not legally sustainable and liable to be quashed. So this is my stand before the appellate tribunal. So it will depend vary case to case. Now, what is being claimed? So this is the prayer part. What is being claimed by the appellant? So the appellant claims that there is no demand of tax leviable upon the assessee, and the entire demand is the entire demand shall be quashed. So this is the claim. This is the prayer that we have to write over here, and it is very important. So also understand there is a character limit. So if we are not able to write all the details or all the points which we are taking up, we can always say that the document has been uploaded as annexure this, and you can refer to that. Then comes the point. So since this was only relating to the issue of tax, now we have to raise the point issue relating to the levy of interest or levy of fine. So again, we have to write all the details. What was done by the adjudication authority? What was done by the appellate authority? What was the stand before the tribunal? And what is being claimed as prayer? Similarly, uh, since there is also a penalty levied upon me in this case, so we have to select an option and add more issue, and raise the levy of penalty in the case summary point. Since we are it would take time, I would be moving on. So now we have to mention the about the appellant details. So here we have to mention what is the GST number. In the case of the company, we have to mention the CIN number, the constitution of business. Since it is a proprietor business, we have to write proprietorship. If it is a partnership or a private limited or a public limited, we have to write accordingly. A statute under which it has been incorporated. So the firm was incorporated in GST period only, and on from the 1st July 2017. But here it is very important. What is the commencement of the business date? We have to give the detail from date from which the business was commenced. Since in my case the business was commenced from the 1st July only, I have selected this. But in cases where the business was commenced before the implementation of GST, so we have to select that date. The address of the registered place of business address, we have to write over the nature of business and any other relevant fact if required. Now comes the statement of facts. So here, friends, it is very important that we properly show what are the statement of the facts, how the case has been evolved. So in my case, the case has been evolved from ASMT 10, then issuance of DRC 01A, DRC 01, that is the show cause notice. Then the reply was filed, and after the reply, DRC 07 was issued, against which we filed an appeal before the first appellate authority. A personal hearing was done, and then that APL 04, that is the appeal order and appeal, was passed. So we have to display each and everything over here. So as you can see, I've shown what when the ASMT 10 was passed, it was passed by whom? The original adjudication authority, or if the order was passed by the appellate, then what was the narration? A small narration why the demand was raised, the reference number or the acknowledgement number, and the date. Similarly, when the show cause notice was passed, the details of the show cause notice and the action by whom it was passed. Then the reply against which the order was passed, that is the action by the appellant. The brief narration of the appellant, what was the reply made, and the date on which it was filed. Then the DRC 07, then the APL 01 was filed, the APL 02 and the personal hearing notice details, and then the APL 04. That is the order in appeal was passed by the appellate authority. If there was a case where the revisional order was also being passed, so we have to select the revisional authority. Since in my case the order was passed by the first appellate authority, I selected the appellate authority. So this is the main page of the GSTAT portal, and we have to fill it very carefully because this would be appearing before the tribunal members. So after filling the details, we have to click on the next. Now comes the appellant details. So as you can see, it is auto-filled. The name of the appellant, the GST number, the official address, the email ID. The email ID and the mobile number has to be filled by us. Once we fill this, we have to click on save and move on. Now comes the respondent name. So here we have to select the respondents, and we have to be very careful who we are making respondent. In every case, the order in original that is the adjudication authority has to be made respondent. It is very important to know order in appeal. The first appellate authority is not required to be made respondent. We have to make the original adjudication authority and the commissioner, the commissioner under whose jurisdiction the order was passed. Since in my case the order was passed by the joint commissioner, I can show. Let me show you from the DRC 07. So the order was passed by the joint commissioner, Circle D, Jaipur I, AC CTO ward. So as you can see, I've uh, filled all the required details. That is the name of the respondent, designation of the respondent, the office address. That is as written in the DRC 07, Circle D, Jaipur 1, AC CTO ward, Jaipur. And if you have the mobile number and the email ID, since in our case the email ID was available on in the annexure to the DRC 07, we have filled that email ID. So once we once we submit those details, we click on save button and it will appear here in the respondent list. So now, after mentioning the respondent details, we will be moving on to the next page. And this is the very important page. So now the GST portal has given two options, that the representative can be filled on a later stage, or it can be filled right now. Since I'm already authorized by the appellant, so I will be filling my details. If let's say the appellant was filing the details, was filing the GST appeal by himself, so he can on the later stage add representative. So here, what is important to note, that the authorized that is us, the chartered accountant or the advocate or the cost accountant or the company secretary, we have to make ourselves representative. And how do we make ourselves as representative? We have to register ourselves along with our registration certificate and Aadhaar card and photo on the GSTAT portal. So once you are registered on the GSTAT portal, you can make yourself as an authorized representative and add yourself from the list. Let's say, so once you are registered, so you can always click on search representative and click on write your name. And as you can see, my name is appearing on the portal. So you have to register yourself on the GSTAT portal to get appear in the search representative option. So we have already filled who are the representative who will be who are authorized to attend before the GST Appellate Tribunal. So once we fill that, we click on next. Now comes the most important portion, the demand details portion. As you can see here, the demand is showing as the demand details. The in my case, since the demand was confirmed in the IGST Act, so as you can see, the determined amount in DRC 07, that is the tax amount, the interest amount, and the penalty amount, and the amount which was disputed by me during the filing of first appeal. So since in my case I disputed the entire amount. So here, as you can see, and the appeal was filed online, you can see that all the details have been auto fetched. Similarly, if there was a case where the order was passed offline and the appeal was filed online offline before the first appellate authority, then all the details have to be filled manually. So we have to write each detail manually. What was determined in DRC 07, what was disputed amount in APL 01, and what was determined before the first appellate authority. So uh, as you can see, all the details have been auto fetched in my case, since the order was passed off online and the appeal was filed before the first appellate authority on the portal itself. And then the APL 04 was also uploaded on the portal by the first appellate authority. So once we check all these details, we have to click on confirm details. So as you can see, I have confirmed the details. Now what comes is the amount admitted and the amount disputed. So let's say if you are admitting some portion of the demand, then you can always fill those details in the CGST head or the SGST head or the IGST head, as the case may be. And since in my case there is no admitted amount, I have admitted zero and filled zero. So once it is submitted, as you can see, amount under dispute is clear over here. So as you can see, the amount under dispute is the entire demand which was raised upon me. That is 11,60,360 rupees, and along with the interest and penalty portion. So as you can see here, the amount under dispute is showing, and the 10%, the pre-deposit which is required to be made for filing of the appeal before the appellate tribunal is also being shown over here. So as you can see, the amount payable is being shown. That is 1,16,036 rupees. And if there was any such demand, it would also show here. So now in the total head, you can see the amount disputed and the amount admitted, the amount under dispute, and the amount payable. That is the 10%. So if there was a case that in which the only the interest and penalty demand was raised, so we have to deposit 10% of the penalty amount. and it would be shown as amount payable under the penalty head. So once we check this, we click on save and next. Now comes the amount exemption or self calculation. So in some cases, the if the SSC or the appellant has went to the High Court and got an order from the High Court regarding less exemption of pre-deposit amount, then we have to state that details over here and state the percentage of exemption that has been provided along with the uploadation of the order. Since in my case we did not went to the High Court and there was no exemption regarding the pre-deposit amount, we will select no and click on save and move on. So now comes the final details. That is the central tax demand, the state tax demand, the IGST head demand, the cess demand, and the total demand. So the total demand, as you can see, the amount under dispute, you can see over here, the amount already paid. Since in my case, I've already adjusted the demand payable, the pre-deposit payable. So it is appearing over that the amount has already been paid through the adjustment ledger or through form DRC03A. So once we deposit the demand, we have to click on refresh so that the data can be fetched from the GST portal. So once you pay the demand on the GST portal, then you click on refresh and you can see that the amount already paid would be coming over here. If the amount was not paid, it would be coming under amount already amount payable. So since I have paid the demand, the pre-deposit, I will be clicking on save and next. So now, as you can see, the payment of amount. So once the pre-deposit has been uploaded on the portal, it will show on the GSTAT portal as your pre-deposit payment is confirmed. Please proceed for appeal fee payment. Appeal fee payment is a court filing fee payment that we have to do at a further stage. Now we click on save and next. Here comes the most important procedural part, and it has a lot of confusion. So let me explain you each and everything. So the documents which have to be uploaded on the GSTAT portal. Let me first show you the list of the document which has to be uploaded on the GSTAT portal. Just a minute. Yes. So these are the documents which have to be uploaded on the GST portal. The show cause notice, the reply to show cause notice, the order in original, copy of the appeal filed before the first appellate authority, that is the form APL 01, any written submission, first appellate order, that is the APL 04, and the payment proof, the pre-deposit of the appellate tribunal, along with the court fees and the appeal documents before the GSTAT, that is the statement of facts, the grounds of appeal, and the prayer. Then if there is any condonation of delay, then we have to file the condonation of the delay on the portal also, and the wakalatnama or the authorization letter. The wakalatnama or the authorization letter has to be filed along with the GSTAT form 04. That is the memorandum of appearance. So as you can see, all the points which have been shown in the star are required to be mandatory filed. So these are the documents which have to be mandatory filed, and as per the office order number of the principal bench and the instructions dated 14th May 2026, the GSTAT is advised that the scrutiny officer shall not raise defects if the AP 05 contains all the details, that is the show cause notice, order in original, order in appeal, statement of facts, grounds of appeal, pre-deposit proof. Everything is uploaded on the portal. Then we don't. Then the scrutiny office shall not raise defects and give us the final acknowledgement. Now the important points for document upload. So friends, it is very important. So the documents. Let's say the order was the APL 01, the DRC 07 was uploaded on the portal and was digitally signed by the authority who has issued it. Then we don't need to self-certify it, or at the time of the filing, we don't need to have it digitally signed by of the appellant. Similarly, if there are a certified copy or any other, if there are any physical documents that are being filed, then those shall be self-certified by the appellant or the authorized representative at the end of the each page, and all the documents which are being filed on the portal shall be properly numbered and indexed. So we will be sharing you a format which will be useful for everyone to upload on the GST portal. We will be sharing you with the format of the index also. And all it is important to note all the documents shall be scanned in a A4 paper and at 300 dpi or less, and all shall be legible. The maximum upload size which has been given by the GSTAT portal is 20 MB. And so once the document is uploaded on the portal, as you can see, there are three options on the GSTAT portal. If you can see on the portal, that is the submit with the external DSC utility, submit with NIC DSC utility, or with Aadhaar based utility. So whenever you are uploading a document, let's say we have to select appellant, then the document type. Let's say you are submitting show cause notice, which was issued to me. So you have to select the show cause notice in the PDF format, and it will show you a preview what is being uploaded. So let's say the order, let's consider this order was uploaded and was manually signed. Then we have to self-certify it by either using the DSC utility option given on the portal, or the Aadhaar-based utility option, or physically or attaching the digital sign before uploading on the portal. So there are three options, and I will suggest you keep the DSC ready and sign each and every document which is being uploaded on the portal, and then select the submit with the external DSC utility. Otherwise, the process of uploading the document would be very time consuming. So as you can see, I've uploaded all the documents, and the number of pages have also being shown over here. What are the number of pages and everything. So once we upload all the documents, then comes the checklist. So the checklist is basically a GST portal checklist that is asking you whether the order which was uploaded online is a self-certified copy or not. So we can select yes if the order is self-certified, or if the order was digitally signed, we can always select no and click on digitally signed. As the order passed by the appellate authority been uploaded with self-certified copy, as have the issues under dispute before the tribunal has been clearly stated in the present appeal. So friends, it is very important that all the issues, whether it is short payment of tax or denial of ITC, all of those points have to be considered very properly, and each issue has to be raised separately on the portal in our statement of facts and grounds of appeal. Against each point, a separate grounds of appeal shall be prepared. The case summary under dispute has been provided in the present appeal. The statement of facts has been uploaded. So all the this is a checklist which is being provided by the GSTAT portal, and we have to select yes, no accordingly. Has the appeal been prepared in English? If any orders were passed in a language other than English, has an English translation has been uploaded? So in this case, I would like to tell you that the GSTAT portal has provided a temporary relaxation that if the orders were passed in Hindi, then we don't need to upload the translation immediately, but at the time of hearing. So this has provided an option. The office order issued by the principal bench through letter dated 22nd April 2026, that a temporary lenient approach may be taken, but this does not friends, this does not limit that we don't have to file the translation. At the time of the hearing of the appeal, we have to file the translation if the order is not being, if the members ask for it. Because there may be cases that the member is from the south and is sitting at a north bench. Then he would not be able to understand Hindi. For all those cases, we always have to file the translation. It can be filed at a later on stage, or it can be filed at right now. It is on the option of the person who is filing the appeal. So once we submit each and everything, all the affidavits being properly attested and identified, we will be sharing you with the format of the affidavit also in the group. So uh, if it can be useful for everyone. And then has the order type has been correctly identified in the present appeal, has the required pre-deposit amount has been paid, that is under section 1128 of so since in our case everything has been done properly, so we are clicking on yes. Have all the documents been uploaded with the correct indexing in a single PDF? So in our case it is yes. Have all the document requiring the signature of the partiture physically signed, scanned and uploaded? So we are in all our pages. Let me show you an example. We are properly filled self-certified the pages. So as you can see, let me show you a statement of the facts if it is visible. So as you can see here, it is legibly mentioned before the Honorable Goods and Service Tax Appellate Tribunal, that is the State Bench, Jaipur, Rajasthan, and in the case in the matter of Bhavya Gems and the GST number. So as you can see, we have prepared a statement of facts, and the statement of facts are the consecutively numbered. That is A, B, C, D, and all the details regarding when was the ASMT 10 issued, when the show cause was issued, the reply to the show cause was filed. Each and everything has been mentioned in the statement of facts. So, with a brief note, we are also uploading a detailed statement of facts. And so as you can see at the end of the grounds of appeal also, these are the grounds of appeal. Each ground is being raised, and so as you can see, we have for Bhavya Jain, that is all the documents shall be signed by the or self-certified by the appellant or the authorized representative. So now moving forward, once we click on each and everything and select have our form of appeal and attached documents are properly paginated and indexed. So we have properly paginated each and every page and indexed it. I will show you an example. So as you can see, there's a proper pagination of the page, and we have also the index. So this is the complete file which was required to be uploaded. As you can see, this contains each and everything. That is the Shoka notice, all the annexes and everything. So each page has to be properly paginated and indexed. And the index shall be properly filled and uploaded on the GSTAT portal. So once you submit all the documents and go through the checklist, yeah, you will go to the option of the court fees. As you can see, now the most important point. You can see the court fees that is coming over is 12,000 rupees. So how the 12,000 rupees has been calculated? As Sakshi ma'am told you, the appeal or the court fees is calculated on the tax portion. That is, in my case, since the demand is of 11 lakh 60,000 rupees, so the payable amount, that is per lakh 1,000 rupees is the court filing fees. So in our case, since the demand is of 11 lakh 60,000, so the 12,000 rupees demand has been court filing fees has to be deposited while filing the appeal. So once we submit this via online method or offline method, we can either pay it to through online by net banking, credit card, debit card, or we can through pay through it Bharat Kosh. So once we pay this demand, then comes the final preview, and after the final preview comes the acknowledgement. So a 16-digit filing acknowledgement number is given to you once after submission. So this is a provisional acknowledgement. Once the registrar certifies it and states that there is no defect in the appeal, then a final acknowledgement is issued, which is under Form GST APL 02 Part B. So, friends, this is the online filing part that we have covered over here. And as you can see, the filing is very easy once we go through the process and prepare all the documents and do all the working beforehand. So now we will be starting the Q&A part, and I would be transferring to Pankaj Ghiya sir to start his deliberation. Over to you, sir.
Thank you. So, friends, we had a wonderful session by the two speakers. They had given you all the nuances of the filing of appeal, how to file the appeal, what are the difficulties, what are the documents required, how to take the documents, put them serial wise, prepare the indexation, file it online, deposit the amount, and a literal online filing by Ribhav Ghiya. Friends, the only thing which people are saying time and again that the filing online is very, very difficult. What you had gone through this time, you must have found that if you have all the documents, if you had all the working together, prepare the index first, keep all the documents as per the index, and keep it online, and then you start the filing. You will find that the filing is really very easy, very simple. The question of how to calculate the pre-deposit, how to calculate the filing fees, and other thing, you will have to understand, and that thing is very important, because if you understand how to calculate the pre-deposit, that is additional 10%. Because now the biggest question which is coming every day, I am facing, my team is facing the question how to deposit additional 10%. Most of the people, they are finding it financially very difficult to deposit additional 10%. Sometimes the people are having appeals for 3 years, 4 years, 5 years together, or multiple appeals, and then they are required to pay multiple pre-deposit and multiple filing fees. That is really becoming a financial burden for all of them, and you will have to understand that without that you cannot file the appeal. So that is very important. You will have to update it. What I suggest at this juncture is make a table of the total demand, the total pre-deposit required, total filing fees required, your professional fees, and your filing expenses, and inform it to the client immediately by WhatsApp or by mail or by letter or whatever it is, immediately, and tell them that the appeal has to be filed before 30th of June 2026 positively. Prior information to the client is very mandatory, because sometimes if you fail to inform the client, or you, if we deem that the client would understand and he would come to you, that can be a problem. And in the last date, even the portal may tumble, even the portal may create some difficulties, and then we will have to wait and watch, kill our time, spend our time more on the portal filing and other thing, and the client will have difficulties for arranging the funds. But there are many other things I would be talking about. But before that, I would be going through the chat box and answering all the queries which has been raised in the chat box. One, Mr. Devanshu has raised a query: if we file condonation application with High Court ruling, then tribunal can accept the appeal or not. If the High Court says that the appeal has to be accepted and decided on merits, the tribunal has no authority to say they cannot hear the appeal. So, but normally what the High Courts are saying, when you go to the High Court under the condonation for the first appellate authority, the High Court is always saying, okay, we give 15 days time or 4 weeks time or 6 weeks time to file the appeal before the first appellate authority. So if the High Court is giving time to file the appeal before the first appellate authority, you don't have to rush to the tribunal. You have to go to the first appellate authority again, file the appeal again, and ask them to decide the appeal on merits. And then if on the merits the decision is against you, then you can go to the tribunal. But if the decision is in favor, then sit tight. Maybe the government may appeal or may not appeal, because your amount may be within the threshold limit of the government of non-filing of appeal or whatever. The second question is by Mr. Saurabh, Aman Singhal, and Bhaskar Abad. It is almost one and the same question by three persons. Can we directly go to the tribunal without going to the GST Appellate Authority because time left for first appeal? Aman Singhal has said, what if first appeal was rejected due to time bar? Can we apply for GSTAT or should go to High Court? And Bhaskar Abad has said, first appeal is rejected due to delay filing, condonable period also lapses. What remedy is available now? Or also can we file appeal to GSTAT now? Now all these 3 points was answered by me in the opening remarks. Friends, you have to understand, GST Appellate Tribunal is a creature of the statute. It is created under section 112 of the CGST or SGST Act. So they don't have power to condone any delay except what is provided in the statute. In the statute, it is only provided 30 days delay or 3 months delay before the tribunal. So if any extraordinary delay is there, then only the High Court is competent, and that too under Article 226 of the Constitution by way of filing of a writ petition. So the what is the remedy? Remedy is, if the first appellate, you have filed an appeal before the first appellate authority and they had rejected on the ground of delay of beyond 4 months, go to the High Court by way of filing of a writ petition. If you are in the process of filing of appeal, but you had not filed the appeal, but 4 months had elapsed, again the remedy is go to the High Court directly, explain the reason why the delay has occurred, why you could not file the appeal in 3 months' time or 4 months' time, and then the High Court may give you a condonation because recently in Makhanlal and Sons and Rajesh Kumar Ramauta, the Rajasthan High Court has said that if there is a reasonable ground, then the delay can be condoned and further time of 15 days or 4 weeks can be given to the petitioner to file the appeal before the first appellate authority. We will be sharing those orders in the group if you had joined the group very shortly after the culmination of this masterclass, and you will find that order helpful if you go to your jurisdictional High Court. The question is where to file the writ petition. The writ petition can only be filed before your jurisdictional High Court. If you are in, say, Maharashtra, you have to file before either of the bench in Bombay or Aurangabad or other places. If you are in Madhya Pradesh, you will have to file the appeal writ petition before the concerned bench of the High Court, either at Jabalpur, Indore, or Gwalior. So these are, or if you are in Tamil Nadu, you will have to file the appeal before the Madurai bench or the Madras before the Madras High Court. So all these type of things, you will have to take a call where to file the writ petition, because it can be filed where your territorial jurisdiction is covered under the jurisdiction of the High Court. Now, one Mr. Hamesh Madan has given a very good question, and it is very important, and it would be covering the question for all of us. It is very important to understand what was the question. The question is, if my order was communicated and then I filed a rectification, waited for 3 months, and later sent a reminder to the department, but they rejected my rectification, will the 3-month time period start from the date of the order of communicated or the date of rejection of my rectification? Now, this is a very common mistake. Very common mistake each and every tax professional is doing. I will say, if you get an order in original when it is communicated, if you are aggrieved by that order in original, you have to file the appeal immediately. If you had even filed a rectification, even then you file an appeal. You will say, sir, there are many High Court decisions which says that if you had filed the rectification, then the limitation would start after the rectification is decided. But my dear friends, for that order, you will have to go to the High Court. The client will have to bear the extra litigation expenses. The client, you cannot file the appeal because the appellate authority is bound by section 107, and there is no exclusion in section 107 that you wait till the time the rectification application is decided. So the only remedy then would be available, again go to the High Court, though you will get a positive order in all likelihood from the jurisdictional High Court. But then the litigation and the time spent for litigation and the expenses for litigation would be additional. and that would be a burden for you and for your client. So don't do it. If the order in original comes, file an appeal and file a rectification application. If the rectification application is allowed, partly allowed, or rejected, whatsoever the case, what you can do is you can always go and amend the ground in your appeal, and you will get a benefit out of it. Mr. Ashish Ghai has put up a question. Sir, this 30th June has been provided to file GSTAT against first appeal order before 31/3/2006. But what if GSTAT is not filed on or before 30th June? Will the delay condone of 3 months as provided in section 112 will apply or not? Again, a very, very intelligent and pertinent question. My opinion is very clear. The time limit for filing of appeal before the GSTAT was 3 months. The GSTAT portal was not ready. It was not our fault. It was not the assessee fault. It was the fault of the government. It was the fault of the GST department. And therefore, they continued to extend the time. And now they had given up a time of 30th June 2026. So even if you are not able to file the appeal, the 3 months condonation, in my opinion, would be available, and you can apply with a 3 month condonation limit before the GST Appellate Tribunal. Because what the GST Appellate Tribunal says that the time limit has been extended up to 30th June 2026, not the condonable period has been extended. So therefore, my opinion is there may be a controversy, there may be a conflict of opinion, but my opinion in this respect is very clear, and you will have to understand that this is what the clear reading of the provisions and the time limit which has been extended by the GST department says. One Mr. Sagar Sharma has put up a query. Can we pay pre-deposit through credit ledger? Yes, pre-deposit can be paid through credit ledger. There is no doubt about it. But for the filing fees, that cannot be paid through the credit ledger. That has to be gone through the Bharat Kosh. You have to register yourself at the Bharat Kosh, pay that amount first there, and then transfer it to the GST Appellate portal. One Mr. Hardik has said, what would be the pre-deposit if some amount of demand is dropped in OIO? If some amount of demand is dropped in OIO, then the pre-deposit would be calculated on the remaining amount, because what you are going before the GST Appellate Tribunal is for the disputed demand, and the amount pre-deposit would be calculated according to it. One Mr. Chere Thoria has stated what action need to be taken where the officer of recovered amount even after depositing the 10% pre-deposit. Now, friends, that is a very thoughtful thing. In many of the cases, they had attached the bank account and they had recovered the amount totally, or whatever the amount was available in the credit ledger or the bank account. In one of the cases, we had filed the writ petition before the Rajasthan High Court, and I had also appeared and filed writ petitions before the Honorable Gujarat High Court and the Punjab and Haryana High Court. And in some of the cases, the bank account was released. In one of the cases in Rajasthan, they had said the amount has to be refunded. So, friends, but that is all to be done through the writ petition before the High Court. You cannot, here, you can put a grievance before the grievance portal or otherwise, but no action would be taken. The GST department, as you know, how do they work? They will not take any action. But if you want a real refund, and there is a substantial amount involved, it is better to go to the High Court by way of writ petition. But the fact should be very clear, and you should have a clear-cut case in that matter. One Mr. Devashish Nandi. What can be done if the first appeal has been filed with a registration number which is temporary and has been discontinued? Now GST registration has been taken with the current GST number. Pre-deposit has been made with the previous number. Now filing fees has to be paid with the current number. Friend, this is a controversial case. In this case, you will have to go with the number which is active, and accordingly you will have to file the appeal. And what you can do is you can put a current note in the grounds, in the facts, and it would be clarified if there is any defect raised by the GST Appellate Tribunal, and if any defect is raised, you can always clarify it through there. Mr. Paresh Babaria, we have filed appeal with GST Tribunal. Our client had delayed filing appeal with GST Commissioner by 7 months. We are advised that writ with the High Court recently was against SSC. Asked to file appeal before tribunal. Mr. Paresh, I think that is a wrong advice. The tribunal has no power to condone the delay. It is advisable to file a writ petition before the High Court. Whatever the advice given, that the view of the High Court is not favorable or otherwise, I don't know which High Court you are talking, but Madras High Court or Rajasthan High Court or other High Courts, Gujarat High Court, Punjab and Haryana High Court, I am appearing in many of these High Courts, and most of the High Courts are favorable, and they are giving time to file the appeal if there is a plausible reason, reasonable reason for the delay, and that is very important, and that is where you have to understand. Rupa Gami, whether each and every document has to be filed now or we can file certain documents later. Friends, Ribhav Ghiya shared you a list where what documents is to be filed and what documents is not to be filed. In that document PPT, we will be sharing the PPT very shortly. In that document PPT, what you will find is red asterisk is marked. Where the red asterisk is marked, that documents has to be uploaded mandatorily. But if the red asterisk is not marked, that is a optional uploading. And if you are not able to file it right now, maybe at a later stage also, if you are asking from the court, you can be able to file the documents. It is also important that this tribunal is not e-tribunal. You will get a physical hearing. So at the time of physical hearing also, I don't know what would be the procedure, but normally if paper book is submitted prior to the arguments of appeal, normally the tribunal accepts the paper book for consideration. Over Mr. Prakash Srivastava raised a very good question. Will appeal file through the authorized representation login or the assessee login portal? Friends, everything would be done through the assessee login portal. There is nothing called authorized representative portal. It is the assessee login through which the GST appeal would be filed, because all the data would be fetched of that assessee. Assessee for the AR, you have to register on it, and you have to give your registration number. For advocate, you have to give your wakalatnama and the registration number, and for the chartered accountant and other practitioners, you have to give your registration certificate, so that they may be taken on record, and you will have to file form 04 with it. Akhilesh Garg, when there is a limit of character in filing in tables, can we leave it blank or simply write attached and attach separately our full submission? You can do either way. But what I would suggest is give a synopsis or a small summary in that table, and at the end you write that the detailed submission are enclosed as PDF as per the attachment enclosed. Shelja Mohan, can we mention in respondent name Assistant Commissioner who passed the original order? Yes, the respondent would always be the authority who passed the order in original. Order in appeal does not become a respondent. Respondent for all litigation purpose will always be the person who has passed the order in original. Even sometimes the SCN can be issued by a different person, and order in original can be passed by a different authority. So the respondent will always be the person, the authority who has passed the order in original. Don't be ever confused by it. Somnath Gupta, sir, in my case, AC and CTO both issued same notice. I represented my case in front of the CTO. Case has been closed. But after some time AC passed, DRC 07 date was over. May I also move for 23,000 rupees, 23,000 only? Very difficult. You will have to go through the first appeal rigmarole, but that has to be done. The amount is very petty. Maybe you can take some recourse. If that limitation is there, you can file a rectification, or otherwise you will have to go through the first appeal route only. Navneet Arora has raised a very good question. Sir, you have said that respondent should be adjudicating authority, but in my case, in first appeal, entire penalty was dropped for rupees itta under 122 and imposed penalty of rupees itta under 125. Now, who will be the respondent? Friends, the appellate authority may amend or change the penalty or reimpose the penalty, but the respondent will always be the person who has passed the order in original. You have to understand that the respondent would never be the appellate authority. So be very clear about it. The respondent would always be the person who has passed the order in original, and that would you have to mention it. Whether it is mandatory to translate OIO in English if it is passed in Hindi, Arunjan, as per the translation rules, yes, it is mandatory, but up to December, some relaxation is given by the president of the GSTAT. So maybe there may not be any objection to it, but yes, you will have to prepare with the translation unless and until any other directions come to the fold. Ashish Ghai. Sir, please also elaborate on appeals filed by the department against the first appeal order in favor. Very good question. Friends, 80% of the appeal filed till now, as per my discussion with the officers of the GSTAT or the benches at various states, I had found that they had said that 70 to 80% appeals had been filed by the department only. The assessee filing is very slow. The assessee filing is very slow because they are confused or they are not able to give pre-deposit, or most of the assessee appeals are in defects, and only 20 to 30% appeals filed are by the assessee. 70 to 80% appeals filed as on date is by the department only. RR Mehta and Company. I have a manual order, so how to make appeal to the tribunal. If pre-deposit amount paid, then it will automatically fetch as amount paid, right? If not, if you had filed the first appeal, you must have filed it online. There is no concept of filing of first appeal as a manual appeal. So whatever the details you had given for the first appeal, that detail would be suffice for filing of the second appeal, because the first appeal order would also be available with the ARN generated with the order passed in appeal, that is OIA, and that would be the concerned document. With that, you can file the appeal before the GST Appellate Tribunal. Arun Jain, Pankaj Kulkarni has said authorization should be stamp paper. The authorization is not required to be on the stamp paper. It is a simple authorization, power of attorney. You can give it on a plain paper also, and you will have to check the rules for it. Whether court fee stamp is to be fixed on the Wakalatnama, friends, you will have to go with the provisions of the Advocates Act. The Advocates Act and the Stamp Act provide that the court fee stamp and the welfare stamps has to be affixed on the Wakalatnama as and where it is used. So, as and where it is used, as an advocate, it is mandatorily as per the requirement of the state that you fix the welfare stamps and the court fee stamps on the Wakalatnama. Apart from that, there are certain 2-3 queries also, which says that it is from Rajinder S. Appeal filed manually against order MOV 7, but till not update in GST web portal, so not able to file by online. If you had filed the first appeal, you will have to ask that authority to decide the first appeal, because the first appeal cannot be decided unless it is available on portal. Mr. Rakesh Kumar, you practice under chartered firm gathering knowledge, then you decide practice before GST. I don't know what is the question. One Mr. Madhvendra Narayan has said, could you please explain pre-deposit? Now, a very basic, simple thing. Pre-deposit is the amount required that is to be filed before your appeal can be entertained. Suppose, for example, your disputed tax amount is 1 lakh. For the first appeal, 10% pre-deposit would be 10,000. And for the second appeal, again, there is a requirement of 10% pre-deposit in addition to the pre-deposit already made. So again, 10,000 has to be made pre-deposited. This pre-deposit amount can be deposited either in cash, or if you have a input tax credit in your electronic credit ledger, through your electronic credit ledger. Friends, the matter can go on, the questions can go on, but the time is very important. 2 hours has passed. We don't know how fast it has passed, and it is all your love and affection that this 2 hours have passed. If you have further queries, share it on our group, and we'll try to reply as much as possible. But I would say we will be coming again shortly with another master class on some other topics, even for the arguments or drafting of appeal and other things. Share your feedback. Share what else we can do to improve our presentation. Share what topics you want so that we can come up with a master class, because your appreciation, your motivation, and your pointing out any new things would always help us to achieve better. These two young speakers have given you the best of the best with the presentation, live presentation. Sakshi Ghiya and Ribhav Ghiya, both my son and my daughter-in-law, they had given you one of the best presentations. This is my third master class, and friends, in each master class we had achieved a mass love and affection from you all. Give your comments, suggestions, and always your blessings. And we will be coming up with new topics, with new update. Subscribe our group, follow our channels, and we will be giving you updates and everything. If you have any queries, don't hesitate. Send us the message, send it the WhatsApp, and we will be responding to you as soon as possible. With this, I will ask Sakshi and Ribhav both to give a thank you to all the participants, and would request all the participants to give their love, affection, and blessings to them always.
Thank you. Thank you everyone for providing us an opportunity.
Thank you everyone for joining our session, and I hope the session was really helpful to understand the GST filings.
Thank you, dear. Everybody, thank you. And we end this session with this presentation. The presentation will be shared in the group. Please join the group so that you can get the benefit of the presentation. Thank you very much.